consider that?
Actually, no. I do want to go to trial.
All right, so we've got,
Okay, hold on. So you feel like you've had enough time to reflect on what it could be, what you could be considered. Are you saying that you're rejecting that offer because that sends us to a trial? If you're not, I can give you a little time to think about it.
Well,
But we're dealing with, and the state has asked, we've set this for a hearing for the state to make sure, and the court is satisfied that you've received all the discovery that you need. You're going to continue to represent yourself. Is that what you want to do?
correct, sir.
Okay. All right. And who's standby counsel? John West. Okay. So on the 22-39310 sexual assault of a child, a second degree felony, that's the case the state is going to proceed on first. And then you got the other two cases.
I will probably try them all at the same time, Judge.
Is that what you want to do?
Yes, sir. They're all at the same fact pattern. It's the aggravated sexual assault of a child, prostitution, and online solicitation. The state has previously filed a motion to consolidate, as well as giving notice that we intend to ask for the sentences to be stacked in the event of a conviction.
All right.
So today, what I wanted to do, Your Honor, since is currently set on the July 20th docket, was really trying to make sure that we have everything that we need for Mr. Solomon. And since he's representing himself, I prefer to do that on the record. So I know that we conveyed previously, and we had you confirm about written discovery. I've got media discovery I'm going to go over with you. And it's
What are you going to do that?
If he rejects the last offer I'm going to make to him today, Judge, I'm going to have him review these matters. I'm showing, since the record is silent, I'm showing him a media sheet that has 6 different matters that is represented as to the media that's on this. One of those matters includes a report of cell phone evidence that constitutes a report that was provided by the officer that downloaded this information. It is approximately 180 pages. I'm tendering that to Mr. Solomon, who's copying, and initialing that for the record. That way you'll have an opportunity to look at. I don't know, he's had counsel previously where offers have been made, but I don't know what the status of that is. So formally, for the record, I'm giving him an opportunity to take the matter, take a sentence of 10 years on the aggravated, the sexual assault of a child. I'll dismiss the remainder if he accepts that. If he doesn't, I'm prepared to proceed.
So how long does he have to consider that?
Well, I'm assuming that counsel previously, since that's been offered, has talked with him about it. So I prefer to get his answer today.
Nobody's ever talked to me about any offers.
That was what I was afraid of.
Nobody has ever, none of your lawyers, no lawyer has.
Would you like time to consider that?
Actually, no. I do want to go to trial.
All right, so we've got
Okay, hold on. So you feel like you've had enough time to reflect on what it could be, what you could be considered. Are you saying that you're rejecting that offer because that sends us to a trial? If you're not, I can give you a little time to think about it. But we're still going to move forward one way or the other. But
I understand.
But if you thought about it enough that if you're resolved one way or the other.
I have had 4 years, 3 months.
Okay.
Detained in jail, and That is all I think about, and I'm determined to prove my innocence.
Okay. That's what we'll do.
So that the record's clear, the danger there of proceeding to trial, rejecting that offer is that each of these indictments are second-degree felonies. And with the state's prior notice on this matter, depending upon a jury's sentence and the court ruling that the matter can be stacked, his exposure is up to 60 years.
I think he knows that.
I just want to make sure that it's clear for the record, Judge. So if he doesn't have a lawyer that's representing him.
I can object to that. I'm not quite sure of the laws.
Well, that's what the punishment ranges are for each of these cases that have been indicted under that section that they've indicted. But they still have to be found guilty beyond a reasonable doubt.
They do. And when the state actually gave these notices of that intent, when he had hired counsel, Mr. Gertz, all the way back in 23. But we also made those offers that he indicated today that he hadn't heard.
Okay.
Even when I had counsel, Mr. Gerson never sat with me, never counseled, we never went through my case at all, ever.
So we now have the logistical problem of ensuring that he's had an opportunity to see this media, which is why I asked that he be here. So we'll work on trying to get all that resolved so that we can do that for the 20th, Judge. Starting with.
Well, hold on. You're saying so that we're getting the information to him today so that we can try this case on the 20th?
Yes, sir.
Okay. This month.
Yes, sir. It's the top one on the docket as of now, Judge.
Yeah. Okay. What do we do next?
Well, I need him to start reviewing this media.
How's that going to happen?
We've got him here so that we can get that started in the room now.
The jury room?
Yes, sir.
Okay.
I've got an investigator. I'll need to finish the hearing with Mr. West, but I can get him started as far as
Who's his standby? Mr. West is? Okay.
So we may be delayed until that hearing gets started, but yeah, he can certainly start reviewing. And I'm giving him this physical, his own copy of the cell phone extraction.
Okay. Anything else?
No, sir.
All right. Let's get that done. Let's move forward. Thank you.
Would you be willing to sign this, sir?